is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Welcome to Never Never Land. This is Frederick Penny, your host of Radio Law Talk. I got Denise Dirks, my co-host, to the right, and Chris Rodriguez, the Harvard Prince, to my left. Todd Cunin is off today, laying around with his cats in his unmade bed. Welcome.
I can't unsee that picture. I just can't.
Watching YouTube.
Yeah. Welcome, Cal, behind the glass with our call screener, Seth Madden. What a wonderful day today to come and talk law. There is so much to talk about. In fact, we were laughing off the air about how we're just so relaxed now. We enjoy it so much, and when we first started this out, it was kind of a little more rigid, but I'm rolling in 30 seconds before, 10 seconds, and I just sit down and put my headset on. But doesn't mean we're not ready and prepared, because we've done a lot of studying, and we're going to go over a lot of things today. Don't forget, if you want to call in, you can call at 855-LAW-RADIO or tweet us at Radio Law Talk, and if you want to email us, you email us at info@radiolawtalk.com, because we've got a lot of things to talk about that are going on concerning the law and kind of more in the West Coast. What's happening? We got the wildfires. We're going to talk about the wildfires up north in Northern California, the Tubbs Fire, the Atlas Fire, the Nuns Fire, and how devastating they've been and on properties and people's lives, and how liability rolls into that, and who's liable for these fires, and if there's anybody liable, and if there's going to be lawsuits. And the answer to that is absolutely yes, there'll be lawsuits. And there's a lot to talk about that. We could probably talk 3 hours about that. So we're teeing that up for next week. So not to already make you think about next week, but I think Denise and Chris, next week we're going to really lay hold of that. Today we're going to talk about a number of other things, important things. Probably the most important thing is the Las Vegas shooting. Last week we were going to talk about it. We were very sensitive about the issues, and we're still sensitive about it, and sure feel for those people who were injured or who have passed away due to tragic incidents that happen in this country. Not that and we always say, when you're tired of politics radio, you tune in here to Radio Law Talk. But we're all saying we're all Americans. We all care for each other, I believe, even though we all disagree on things. And that's what's great about being lawyers. And as weird as this sounds, as a lawyer, I've learned that it's okay to disagree. See, that to me, in this world, people disagree, and if you disagree with them, they get mad and they think you're a bad person. And so my famous saying is, I'm going to say it here in Radio Law Talk, because I always say, well, let's just agree to disagree and move on in life.
Exactly.
And don't you agree? I mean,
I do.
Denise and Chris, we have friends that are from all aspects of life, from the far left to the far right, are good friends. I mean, they're very good friends of mine. And it doesn't matter where we are in the political spectrum. Let's just make sure that we just all enjoy each other and do the best we can to be good people and move forward. And then in saying that, as a lawyer, everyone's like, yeah, you're a lawyer. You ruin people's lives. Well, actually, it depends what side you're on. So, but we're going to talk about the Las Vegas issue, and there will be lawsuits coming in on that, and there's already 3 lawsuits been filed, and we're going to discuss details about that and what the possibility of who's going to be liable there. That's a huge amount of issues we can push through. We're going to do that third hour. We decided third hours because we do have some stations that join us third hour, so the first 2 hours we're going to talk about some other things. We're going to talk about furniture, how they're changing the furniture in Maine. They have and Rhode Island, and now maybe Connecticut. They're going to be changing some laws about the fire retardants in furniture.
It's interesting that I didn't realize that California is one of the leaders in actually having too much flame retardant in their furniture, such that, and we'll get into the details.
Right.
But it was shocking to me to learn that in California, where we live, children have more of these flame retardant chemicals that come from furniture in their systems. Women have more of that in their breast tissue in California.
Oh my,
and
I
you-
didn't know that.
Oh,
That's
yes.
frightening.
Yes. In fact, like you said, Chris, it was almost like over-regulate. They stepped too far to help, help us citizens so we don't catch fire, basically. It's kind of a catch-22 we're going to talk about. Okay, do we want to catch fire, or do you want to have chemicals in your body?
Yeah, would you rather?
Yeah.
Are they toxic?
Yeah, they're toxic.
Oh my gosh, Prop 65, we're going to talk about that too, which kind of plays into, the warnings that have to happen.
That's exactly right.
Toxic.
We're going to touch about, we talked about Prop 65 before, but then there's some updates we're going to discuss. And then we're going to go in and talk a little bit about what's the name? What's his name?
Meatloaf and Pharrell.
Pharrell, yeah, that's right. Meatloaf and Pharrell, the lawsuits there about copyrights on songs. That's another issue. That's interesting to talk about, whether or not you can copy songs and to what degree you can copy a song.
And the statute of limitations on those is one that I find to be very interesting as well.
I'll probably give some opinions on country music when we get into that, because I personally believe every country song sounds exactly the same. So I think they should all be suing each other.
As I've said before, country has 3 chords. All country songs have 3 chords and the truth.
That's exactly right, Cal. That's exactly right. So we're going to talk a little bit about that, and then push forward on some other minor issues of the law we want to discuss. But we're also going to have case or no case, and we're gonna have our first case or no case. We're gonna tee it up the next segment.
Will Cal be bringing us sealed envelopes?
I don't, Cal, you don't do sealed envelopes here. He does not.
Well, you told me cut down on expenses for the show, Fred.
That's true. That's true.
And if he had it in an envelope, I was able to hold it to my forehead and read it.
We're cutting down expenses because our salary to Chris Rodriguez is so high.
Too high. Yeah.
If you loved the sealed envelope case or no case that we did, which is the only one that I did, and I loved it. If you loved it, call in so that we know that people love it and we can spend the extra 48 cents on the envelope.
Hey.
All right. I'll do envelopes next time, but not today. I will
Start
say
a
this.
petition.
Our case or no case stinks. That's all I have to say.
Oh.
It stinks. There's a little tease for you.
Okay, that's next segment. But Chris, update us on the Ezekiel Elliott, because we've talked about the Ezekiel Elliott issue, and the Fifth Circuit overturned some
Right.
district
So
courts.
real quick, I think I have enough time to kind of give a recap.
Right.
Ezekiel Elliott, running back for the Dallas Cowboys, was suspended by the NFL for 6 games due to an alleged domestic violence incident. And Ezekiel Elliott appealed that to an arbitrator. The arbitrator ruled against him. He went to the district court in federal court in Texas. The judge was apparently a huge Cowboys fan.
Oh, nice.
And enjoined the NFL from enforcing that suspension. So Ezekiel Elliott has gotten to play for the first 5 games of the season. Well, the NFL appealed the district judge's ruling to the Fifth Circuit, to a panel of Fifth Circuit judges, 3 judges.
3, that's right.
Those judges said that the district court judge's ruling was incorrect, and they have now reinstated or removed the injunction to reinstate Ezekiel Elliott's suspension. So you're talking. That's a double discussion. What do you call that? It's
double negative.
Double negative. That's the word. Thanks, Cal. The double negative.
Bottom
So
line,
he can't
Ezekiel
play.
Elliott cannot play now.
That's it.
But if you believe in conspiracy theories, the timing of this is odd, because this Sunday the Dallas Cowboys have a bye, so they're not playing at all.
Oh, so it doesn't matter.
So his legal team has about 10 days to try to appeal to the Fifth Circuit. It's called en banc, which means all of the Fifth Circuit judges,
right,
to try and reinstate the injunction that would reinstate, remove the suspension.
Double negative.
Right, exactly.
Double negative.
Exactly.
Yeah, you called it too. When we talked about this discussion before, Chris, I was thinking it wasn't going to happen, and that I was more on the side of Ezekiel Elliott, but you called it.
Okay, so we're going to come back the next segment and talk about case or no case, something about stink. I don't know what it is. Remember, case or no case, Cal brings it up, and we don't know what he's going to ask us, and we're going to tell you what we think.
I'm sitting 2 feet to the left of Fred, and maybe the topic has to do with Fred.
Figure it out.
We'll be right back.
Hey, tweet us at Radio Law Talk.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penny.
we found a hair laying on the table, and it was blonde, and she's pointing at me. What, Rodriguez? It's not yours, and it's not my hair because I don't have very much. And Denise, I think it's your.
You don't have to be a rocket scientist to figure that one out.
All right, here's the best part of this program is a case or no case. Cal, let's hit the music.
Now it's time to play Case or No Case.
What happened, Fred?
Yeah, let me hear it.
Now it's time
do
to
it
play
again.
Case
Yeah, there
or
we
No
go.
Case.
There we go. Come on.
I like the very end where they clap.
Work with me. Here we go.
All right. That's what. Hey, Cal, you get what you pay for, right?
And I'm worth every penny.
No pun intended.
Okay. All right. So let's talk about this, ladies and gentlemen. I take you now to a deep, dark, dank, solitary prison cell.
Deep, 3 Ds.
Yeah.
Deep, dark, and dank.
And dank. Somewhat like the interior of Chris Rodriguez's SUV.
You've been in it, I see.
Just about that much room.
A prison cell?
Okay.
A prison cell. An inmate is in that prison cell in solitary confinement.
Okay.
The inmate has body odor and petitions the warden of the penitentiary. I was going to save this for the third segment because that's always the deodorant segment. But anyway.
But it's okay.
Yeah.
Denise won't let us do that anymore. She goes, don't say that anymore about our deodorant.
I come prepared. I don't have to add.
Right. Okay. So the inmate goes to the warden and says, you know, it really smells in my cell. And the warden says, well, you're the reason that it smells in your cell. It's your body odor. The inmate says, therefore, warden, you should give me free deodorant to help me live in a more habitable condition. The warden refuses, and so the inmate, acting as his own counsel, decides to file a lawsuit because the warden would not give him deodorant. So, free deodorant. He could probably get it at the commissary, but he couldn't get it free, and he felt like it needed to be free. So, Frederick Penny, case or no case? So would you rather have me defer to someone else first?
No. You can start with me so I can let the other two think, because I'm already thinking about the severe emotional distress
that's good,
issue. Emotional distress. Okay, the question is, do they have a duty to this guy to provide the deodorant? I would say, I'm going to say, of course, they don't. They don't have a duty. And let's assume they do have a duty, because I want to go on to the next thing. If they have a duty, did they breach the? Is there any breach there? Yeah, I think the breach is they make him sit in the smelly room. Is so emotionally distressful that. I think case, and I think he wins the case, and they have to provide free deodorant for him because he can't go out and work for a living, and it's a very emotional. The emotional distress.
So based on emotional distress, you're saying it is a case.
It's a huge case.
If you were a lawyer, Fred,
one that my competitors would have taken.
would you? So you wouldn't take the case?
Or my competitors would.
All right. Since oh, I'm sure. I'm sure. So Denise,
Case.
Since deodorant is an issue for you, no, not. I don't. Wait a minute. I didn't mean that. Since talking about deodorant, that's what I meant to say, is an issue for you. Let's go to you next. Is this a case or no case? And if it is, would you take it?
Okay. First of all, I do think that it's a condition issue. It's about whether or not his cell is habitable. And does the prison owe a duty to him to have his cell be habitable? And he said he wanted habitable conditions. So he could sue to try to enforce them to make his cell more habitable by giving him more frequent showers and giving him deodorant to utilize. And I believe that it's a case.
Interesting. Chris, I guess my only question based on Denise's theory would be, who decides what habitable means? But Chris Rodriguez, case or no case?
So both of my colleagues here have said case. So I'm going to say no case.
Okay.
Just for sake of argument here. And I am going to say that it's no case because it is not reasonably foreseeable
That's a good one.
that this odor issue would make it unbearable or an unfit living conditions for this prisoner. But one of the big questions that I would have is, how often do they allow this man to shower? If they allow him to shower on a regular basis, then I think that removes the foreseeability, because if he's not washing in the places he should be washing, then that's his own problem. If, however, they're making him stay in this cell for a month with no access to shower, then I would say case. But because I don't believe they're doing that, I'm going to say no case.
Okay, I'm modifying mine.
Your Honor, I'd like to come back.
I'm going to come back and modify mine. I'm going to say no case for the inmate, but a case for the prison guard having to smell it. He's got the severe emotional distress, or she. I'm switching over there.
I didn't know you were going to make a joke. I thought that Fred had actually Googled it and now was going to come in and say what he thought was the real deal.
It's the prison guard that's got the real case.
Yeah, he's going to sue for hostile work environment.
Yeah,
right?
That's exactly right. Or workers' comp case. And a good workers' comp case.
And I just got a text from someone who said, "Wait, aren't the people paying for the deodorant? I'm going to buy this guy deodorant."
That's exactly right. So let's
the answer to the question is how many.
Wait. Roll. Do you have a drum roll or something?
I do. I have several things. I have a boomerang. I have drums. I think I'll go with the drums.
There we go.
So the question is it a case or is it not a case? It was actually a case that was filed, but immediately dismissed by the judge as being a frivolous action against the prison. So while it was a case, it wasn't a case. And there you have it, ladies and gentlemen. Case or no case.
So I want to know, though, how often do people in solitary get to shower? Does anybody know the answer to this?
I do not know.
Todd Cunin would know that answer. That's why
he would.
Yeah, he spent time there himself, I think.
Well, he sleeps with the cats in the dirty bed.
That's my point. What's the difference?
His bedroom is called solitary. I've seen a picture. There's a sign on the door jamb that says solitary. Welcome to solitary.
Confinement.
Yeah, no, that's kind of what I was thinking.
We were going to end with a little bit about Meatloaf and Prop 65. We're going to talk about, or Todd Cunin's date life. So we'll talk about his date life when we come back after the half hour here and to our crazy fun time we're having. So we'll be right back.
Objection assumes facts.
That's right, not in evidence.
Show me the money.
Yeah.
Give me your attention, baby.
It's a treasure. RadioLawTalk.com.
About yourself.
Now back to Fred, Denise, and Chris.
We are back talking about the latest topics under the law. We're going to update you on a few issues besides Todd Cunin's date life. Anything about his date life we need to talk about before we go into Meatloaf and Prop 65? Oh, Chris just fell to the ground. What was that about?
Sorry, Fred. You're talking about Todd Cunin's date life. Yes. It is shocking to me that there is one. It is shocking to me.
I hope he's listening. He probably, let's look for, he could be listening. Who knows? He rarely misses. But
I'm just kidding, Todd. I love you and I miss you.
Yeah, that's exactly it. Fun to have you back, Chris, for a little while. But anyway, let's talk about Prop 65. We talk about Prop 65, which is the warnings that need to be put on buildings and on labels in California. And it's a very strict rules when it comes to California and putting warning labels. Now, I want to thank Golfland Sunsplash because one of the general managers of Golfland Sunsplash, Jason Kenny, said, why don't you guys talk about this? Because there's an issue with water parks coming down, the new law that the warnings need to be changed. And actually, the warnings are a little, I guess the word, Denise, is a little more... they can be a little more general, but they've got to be bigger. Like the warning, like the little warning sign, the symbol that's got the exclamation point, it's got to be bigger. And here's the example of what the new Proposition 65 warning says. And the date, I'm going to mention the date that it's rolling in. It was, the new regulations were adopted August 2016, and they're effective August 30th, 2018. So there's a 2-year phase-in period. So what the state's goals for these new warnings were to make warnings more meaningful and useful for the public. Because basically what the state was finding was there's so many warnings, it's so arduous, what happens? And what did we talk about last time?
We
ignore them. them.
Zone them out.
We ignore them because there's 1,000 warnings and nobody looks at them. So that's one of the things they want to make it a little more simplified.
So let me ask you this on the water park thing. Where are the warnings at the water park, and what are they warning you about?
Everything. Go to a water park. They're everywhere and everything. This causes back injury, or it could cause not back injury, but back pain, or it could
warning if this is dangerous if you're pregnant.
I get all that. I get all that, but that's not a Prop 65 warning. The Prop 65 warning is going to say somewhere
chemicals.
The chemicals in this ride are known to the state of California to cause cancer. Where is that, and what chemicals?
And I agree with that. Everything's causing chemical. Why is it in this building? The building we're in right now has a Prop 65 warning because it has chemicals in this building. What's the difference between that and a water slide or a building that's next to it?
Let me give you an example of a smoking area. This is the warning. Warning, it has to have all caps, bold, and it has to be a certain size. And it says, breathing the air in the smoking area can expose you to chemicals, including tobacco smoke and nicotine, which are known to the state of California to cause cancer. Right, and birth defects or other reproductive harm. Do not stay in this area longer than necessary. For more information, go to www.p65warnings.cal.gov smoking areas. So that's an example of a smoking area. And, it sure seems to me like they're just trying to protect themselves from lawsuits.
Yes.
It is.
Right?
It's so hard to not get political in this topic. So maybe just cut off my mic.
Right.
But I mean, we've got so many warnings. I would love to have a video of the people at the water slide, and they get to the top of those stairs, and they look at the warning that says there may be chemicals on this water slide that may cause cancer.
True.
There is not a single person
that's going to
turn around because of that warning. So that begs the question: what is the purpose of putting that warning there to begin with?
They're assuming the risk.
And that's exactly right. Here's the thing. So this is what the state says. What are the state's goals? To reduce, quote, over-warning in which businesses provide unnecessary warnings. Hello, state of California. We've been telling you that for years. You've over-warned us, and then giving businesses clear guidelines on how and where to provide warnings. So this new regulation it rolls in August 30th, 2018. You have to have that implemented. Now here's some sample of new warnings and what they're going to look like. They're going to be huge and big, and it's going to be bigger. I call it like the exclamation point. The little triangle exclamation point. That's got to be much bigger. And so not only is that got to be bigger, there's certain things that have got to be done. So for example, the warning must be all in caps and bold. Warning symbol must be no smaller in height than the word warning. So it has to be the same height as the word warning. Because you know what, Rodriguez, when you go up there and you're ready to go down to that slide and you're worried about the chemicals, and if you see that triangle is a little bit small in the warning, I know that will trick you and you'll go down anyway.
Absolutely.
Don't you think, Denise, that'll happen?
Yeah.
It's like we did a remodel on our house, and one of the things that they made us do is put house numbers on our house that were at least 6 inches high. And my wife went to every website, every hardware store to try to find house numbers that she liked that were 6 inches high. The highest street numbers or house numbers that she liked were 4.5 inches. What are you to do in that situation, and why in the world would you need 6-inch
You
house
put a
numbers?
magnifying glass over them, first off.
Well, yeah.
And secondly, they want them so that when fire departments roll by, this is a case of us living for the government's convenience. They want to have the numbers big enough so that if a public safety guy goes by, they can see them. And apparently they can see the 6-inch ones, but they can't see the 4-inch ones.
Between you and I and the fence post, I'm with that. Because guess what? I'm blind as a bat sometimes, and I'm always looking for the day. Hey, I think they should be a foot high. Oh, there it is.
And
65.
lighted. They should have lights on them.
Yeah, neon lights.
Exactly.
But they should have a warning. These house numbers are so heavy that if they happen to fall off, you may cause bodily injury. Absolutely.
Or lifting them up to put them up.
Absolutely.
No, they should say may irritate your spouse if they're not the right size. That's what they should.
You notice he did say, what was the first thing you said? The first part of it was, My wife trying to find something she liked in that high. I say, the wife's trying to find something they like, first of all, is difficult. Now, don't take it personal. Sorry, young lady over here. But just, it's like, I go shopping with I better shut up. I'm stopping right there. I go shopping with my wife. I'm done in 30 seconds with what I want. It takes hours. So, anyway, let's continue with
Hey,
Prop
are you sure we're
65.
talking about shopping?
Yeah, we were talking about shopping.
Okay.
All right, yeah, just shopping. Text.
Correct.
Rodriguez is back already. The text must be a minimum of 72 points, whatever that means, C-Rod. Sign must be readable and conspicuous before entering the facility. And if the other permanent interest signage is in another language, the warning must be provided in that language also. Now, I guess the issue is how many different languages do we have to be in? I don't know. And that's what I guess every state's going to be different. Does it have to be in California? A lot of stuff has to be. Does it have to be in Spanish? I don't know. That's what's interesting. So, and Denise went through the smoking signs, and then there's ones now for alcohol. There's warnings about alcohol consumption, and in a water park, drinking alcohol. You better be careful drinking alcohol in the first place. But anyway, same thing with alcohol. There's got to be a whole bunch of different warning issues there with the alcohol, and they got to be really tall, and you got to have the big fat warning exclamation point. So guess what? We now know in Prop 65 that's going to be a big change. Those of you who are out there, in 2018, you'll be more sufficiently warned because the triangle with the exclamation point will be the same height as warning. Now you may be able to walk away from that building or going down the slides. And remember, there's radio law talk. We don't talk politics here, but we're just talking about the law.
I think the next question, Fred, honestly, is someone in August should start monitoring the websites that they have on all those warnings to see if they actually get any hits. Because I think that would be a great, if I'm putting my news director's hat on again,
right.
I would have one of my reporters immediately get out there and say, are people actually going to the sites that they warn you about in the warning labels that are all over the place? What's the traffic?
My guess is almost all of the people that write into those sites do it to tell the government how stupid the warning process is. That's my guess.
Well,
hey, you're blaming the government. What are you blaming the government for? You got to blame the lawyers, dude. I mean, the lawyers are the ones bringing the lawsuits for all these warnings.
But I am a lawyer.
I know. That's
so
what
I
I'm
want to
trying
blame
say.
the government.
You know as well as I do, everyone is sitting there yelling at our radio station, all three people listening, saying,
hey,
that they're saying, it's not the government, guys. It's you lawyers bringing the lawsuits for the warnings. And you know what? They're kind of right. It's us lawyers bringing the lawsuits on these warning issues.
But how many lawsuits are filed because people violate Prop 65 because they didn't tell you that the dinner plates you're about to buy or the wine that you're about to purchase has chemicals in it that cause cancer? I mean, this is a vehicle for more lawsuits.
That's what I think. I feel that if they don't have the right wording and it's not exact font and if it's not the exact size, that there's going to be a lot more lawsuits.
So laws made by lawyers so other lawyers can file more lawsuits. That never happens.
Yeah, and not only that, guess what? Most of the judges are lawyers too, and that's what I love about it. Like my father used to tell me, son, I don't know if I've said this at the radio station. I'm going to say it again. My dad said, you know what, at the end of the day, and he was a police officer. He said, at the end of the day, son, I know one thing. Everybody's laying on the ground. There's one guy standing holding the money, and that's the lawyer. And that's what you got to be as a lawyer. Okay, Dad, I'm going to be a lawyer. Well, that's your tidbit for this segment of Radio Law Talk from my dad, Fred Ernest Finney Jr., the police officer. We'll be right back with some more Radio Law Talk, and we're going to talk about Meatloaf and the lawsuits about music and Pharrell's song.
Hey, call in 855 Law Radio.
What do you think? Those are the two different songs, supposedly, or the same songs. Meatloaf's song. Go ahead,
Yes,
Denise.
yes. Meatloaf is getting sued by an LLC, a corporation, and it's called Exposed, I believe, right? LLC. And Enclosed Music, LLC. And they represent two writers named John Dunmore Sinclair and Mike Molina, who wrote the first song that you heard in 1989, and it was called I'd Do Anything for You.
Say that, play that again, that I'd Say Anything for You, Cal. Play that one when you get a second. Keep going, Denise.
They claimed that in 1993 that the lawyer that they had gave the song to Meatloaf, and Meatloaf created his song, I'd Do Anything for Love.
Hey, Cal, let's do it low while she talks about it so we can listen. I want to listen to it while she's talking.
This is the first one, right?
Yeah, the
This is-
first
Yes.
one. I want people to listen while we're talking. If we can play it a little bit lower.
All right, let's go back and cue it up again to that
Yeah.
point. It's all right. Here we go.
Yeah, there. Okay, go ahead. Now listen to it while we're talking. This is the one that supposedly they're saying that Meatloaf stole.
Right, exactly. In 1993, Meatloaf created the song I'd Do Anything for Love, but I Won't Do That. And it was extremely successful. It was off of his Bat Out of Hell, I guess.
20 million albums or something like that it sold. Bat Out of Hell. I'm not quite sure. but
Exactly.
Close.
Right, so the big question here is how can they sue today for something that happened 24 years ago? I mean, that's a very valid question. And it's because in California, the statute of limitations allows for the lawsuit from the last act. So they're claiming that the last act was in Seth Rogen's 2016 movie Sausage Party, because there's a part in that plays I'd Do Anything for Love, and it is kind of a funny little sketch, actually.
But
So
ultimately, doesn't the song have to be like the same song or virtually the same song? I mean, obviously, people take people's ideas and rework them, jump off of that as a springboard to some other creative venture. But my question, in listening to the two songs, and I'm a musician, I have, so I've done all the studying there and so on. Are they really similar songs?
Well, this is what that's exactly the big issue here, Cal. Number one, is it going to thwart other people from writing songs and scare people from writing songs? No, I don't think so. But now with these lawsuits coming up, we're going to talk about Pharrell's lawsuit, but really they got to be able to prove, the plaintiff has to prove a valid copyright or the originality of the work or the defendant actually copied the work, that it was so substantially similar, or that the ordinary observer would conclude that the defendant's work was substantially similar. Or they had knowledge, whether or not they have knowledge of this other song is not an issue, but how substantial. And there's all these details about, does it same sonnet? Does it have the same verse? Does it have the same beat? And
The
that's
same chord progression.
Right, and
that's in this case.
And I think Cal brought it up best. There's only so many chords. Again, we brought up AC/DC can be sued. Everyone can sue them. They had 3 chords the whole time.
And every country writer could sue every other country writer.
That's right.
Merle Haggard could sue himself.
That's exactly right.
Right.
Go ahead, C-Rod.
And you have to have it copyrighted perfectly, too, because if there's an introduction that's not copyrighted, like in the case of Led Zeppelin,
Right.
then you're looking at it's not going to be substantially similar, or it's not going to infringe actually on the copyright.
Yeah, you don't actually have to have a literal filed copyright, too, to sue. You can sue and claim that you still took it, Chris,
Yeah, I mean, so listening to those, and we listened to them, I listened to them for the first time this morning. I think there is quite a bit of similarity. I know you guys disagree, but I can definitely hear, and if you hear the background of the story. So these two writers
right, this is what's
that are
interesting.
suing had an agent or a lawyer. That lawyer went to work for Meatloaf and told them that Meatloaf was actually trying to come up with new songs, and then he ended up coming up with I Would Do Anything for Love. And so they have, for 24 years, been thinking to themselves, this is all just more than a coincidence. Our lawyer took our song that we wrote when he was our lawyer and basically gave it to Meatloaf to work with.
But
Right. I think that because of the Pharrell case, that more people are suing for their copyright protection.
Right.
Well, to me, the core issue is, did Meatloaf actually, what they wanted is lawyers or agents or what they call song pluggers. They take the song and they plug it. They say, hey, why don't you try this song, Meatloaf? Why don't you, Meatloaf listened to it and said, nah, I don't like that. But there's some concepts in there that I think will work for me. So does every coach in the NFL sue every other coach that takes their playbook and says, I see what they do on film. I'm going to use a little bit of this, a little bit of that, but I'm going to put my own spin on it. Is that an actionable offense, really?
Yeah, it's factual. The answer is yes. But the issue is, and we're going to talk about Pharrell's case, it's the facts, Cal. It all depends on the facts. And you know what? It's not just the facts, and Chris and Denise have talked about this before. It's not the facts. It all comes down to experts. And to tell you the truth, it just depends on the jury. As weird as that sounds, you can get the same case in front of 2 different juries in different counties, and you'll have complete opposite results.
Right. And that's so true, especially in the case of the Pharrell and Blurred Lines.
Yeah, that's interesting.
Because Pharrell and Robin Thicke and the drummer, I forgot who the other guy was.
Hey, is Robin Thicke Alan
third
Thicke's
Clifford
son?
Harris.
Yes, he is.
Yes, he is.
Yeah.
They were looking to create music, so they
Right.
were together. They were doing research on the internet. They were listening to other types of genres, and they really liked it and wanted the genre of the 70s. They really were trying for that type of a kick and a new song that would be that way. And it's like Fred said it during the break.
Hashtag Denise on the roof. 70s.
Okay, you just threw me off. No, but it's like what you said in the break. The facts in Pharrell are so interesting. They really are, because Pharrell and Thicke and this Clifford Harris, they took a preemptive strike. So they actually started the lawsuit against Marvin Gaye's estate and tried to get declaratory relief. That's meaning where the judge makes a decision about what's true in their case. So this is not an infringement on this copyright. And it backfired very badly on them. Because of the testimony, the facts that came out was that they did listen to this song. It was one of Pharrell's favorite songs. And they were trying to get this particular vibe in their music. And I think wasn't it the percussion, the drum percussion that was not identical, but so close that that's where the substantial similarity came in.
Can we listen to these? We got these?
Okay, this is now
Blurred Lines here.
Yeah, this is Blurred Lines by Pharrell and
Thicke
Robin Thicke.
and also Harris.
Now this is more Todd speed. He's not here. Okay, now on this, with this song now, the composers, Denise, acknowledged that their track was inspired by Marvin Gaye's song, and that it had relevance. And in 2013, in a GQ interview, Thicke stated, quote, he said Thicke stated that he told Williams that "Gotta Give It Up" was one of his favorite songs.
Yeah. Do we have "Gotta Give It Up"? I don't know it.
He'll get it later. Yeah, I listened to it this morning, and then it's got the beat. So Cal will get it later. But don't forget, it's a fact-driven case, and you have to look at the facts. And they're talking about this Marvin Gaye song all the time. Yeah, this is Marvin Gaye's song right here. Tight pants. I'm wearing tight pants right now, and Angel Flights.
This is identical. I could start singing the other song to this beat right now.
They actually did that.
It's just a beat. It's a 4/4 beat.
Listen to his sound. He's got by far, Marvin Gaye's got the better voice. I'm for Marvin Gaye just because he sounds better. Yeah. See that? That's Pharrell. There's no good music. The 70s are back.
That's actually Thicke.
Or Thicke, or whoever it is. Oh, you said 5 minutes. I think we got 15 seconds left. But all right, we're going to talk more about this. I guess we don't have we're going to have another hour coming up. We probably could talk about it then. Maybe we'll touch on it a little more. But let's talk a little more about Blurring the Lines song. And we'll be right back with Radio Law Talk. Call us at 855 Law Radio.
You've been listening to RadioLawTalk.com. You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated. The following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Welcome to our second hour of RadioLawTalk.com. I'm Frederick Penny, your host, with Chris Rodriguez and Denise Dirks. This prior hour, we've been having a lot of fun talking about the law and working hard to bring you general rules of law and help you out when you think about these issues of going across the country and the latest legal issues popping up. But remember, we're only talking about general topics of the law. If you have any legal questions or you want to seek legal advice about a certain topic, though we are brilliant here and we know almost everything, it is very important that you go and you find an attorney, seek counsel that's going to really be specialized that area of law, and hire them, because there's so many details in a case and in law. We can't cover even 1/10 of it here, but we're just talking about general issues of law.
Yeah, but that shouldn't stop us from taking your calls and answering some of your questions to the extent that we can. So remember to call us at 855-529-7234, 855-LAW Radio, or tweet us at Radio Law Talk. We'd like to also shout out to Amanda Purcell from University of San Diego School of Law. She is our research assistant. She's a law student at the University of San Diego School of Law, and she has done our research this week on many of our topics, and she did a great job. We're very happy to have her, and she will receive a scholarship, and of course, we're shouting out to her.
Yeah, so what we do, it's a shout out. What we like to do is get these great second and third year law students from these good law schools in California, and we'll probably push out to other states, and they do this research for us. We give them $100. It's not going to make their lives, but they get to do the research for one of our segments. We get to give the shout out. We get to talk about the law school.
And they put it on their resume.
It's a great resume stuff. I mean, who wouldn't want to be a research assistant for us, huh?
Yeah, it gives you something to talk about during your interview, right? When the person who's interviewing you looks at your resume and says, "Oh, you did this for Radio Law Talk. Tell us about that."
As weird as that sounds, and you've interviewed people, all three of us have all the time, I would probably look at it and go, "Huh? What's that?"
Absolutely. I don't want to talk about your AmJur award in property. I want to talk about what you did for Radio Law Talk.
That's important. But anyway, thanks a million. Excellent job. And remember, we don't talk politics here. We're when you're tired of politics radio, you tune in right here, and we try to keep it non-political. That's why we keep the mic off as much as possible for our producer. But other than that, it's not too bad. Don't forget. He does the drive-through too much up there in what county is that? Shasta County. Too many drive-throughs in Shasta County. And those of you who listen to Radio Law Talk, you'll understand that joke. But if you don't, you better go back and listen to the podcast. So give us a call if you have any questions. We're gonna continue to follow up about this Meatloaf and the lawsuit and Pharrell's lawsuit on the different copyrights.
It is. It's a fascinating question on how similar can songs be without the subsequent artist running the risk of being sued by the prior artist. And we were talking off the air, and I think this is interesting probably because I grew up listening to a lot of his songs. We were talking about Weird Al Yankovic, and he makes songs that are identical. For example, one of my favorites is Just Eat It, which was a takeoff of Just Beat It. Cal's got it pulled up right here.
Just Beat It by Michael Jackson.
This is Weird Al. It sounds just like Michael Jackson.
Well, it is. It is. Exact same, but different.
Right. I could sing along with this, but I wouldn't want to do that to the listeners.
Hey, he's bopping. Those of you who, we are on YouTube.
Such a fussy young man. Don't eat your Captain Crunch. Don't want no Raisin Bran.
Oh, yeah. Go.
C-Rod. Starving in Japan, so eat it.
Are they starving in Japan? I think he meant like Vietnam or something.
Well, it rhymed with man.
But so the question is, now get back to a serious legal topic. Well, Seth is laughing at me back there. Why doesn't Weird Al get sued?
Yeah, tell us.
He got to make a ton of money off of Michael Jackson's songs. And so we were talking about it off the air. Cal made a good point. He likely went to most of these artists and made an agreement with them, and maybe had to share some of the money with them. I don't know.
I'll almost guarantee he did.
Right, but the other part that Denise brought up is if you make a parody, if you're making fun of a celebrity, you can do that in a lot of circumstances without having to pay them because they have made themselves part of the social consciousness, and now other people get to make fun of them at their expense.
But my argument would be, though, you're doing it for gain and financial and for money, and therefore then you may be liable. That's one of the prongs that you got to look at, and because there are exceptions, you can copy things and use things if it's for a very short time. For example, Cal knows this, and we even bring it up. Like, we use a lot of other people's songs and stuff, but if you just do a quick blurb, and we're not doing it trying to make money, we're talking about the topic here. And so it comes down to it's the manner and how you use it. And if it's for you're playing it at the school, at your kid's school, you're not trying to make money off the thing. And those are some issues. But let's go back to the Gale family lawsuit against Robin Thicke and Pharrell. Just so you know, they did win. The suit was they won $7.4 million in damages.
And that was by way of cross-complaint.
Right. So we brought that up earlier.
Yes.
So explain that really quick again to those people who didn't hear that.
Yeah, well, Pharrell and Thicke and Harris, they brought the suit against the estate of Marvin Gaye as a preemptive strike. They wanted to have the court declare that their blurred lines did not infringe on Got to Give It Up copyright.
And so therefore they lost basically on the cross complaint.
They
lost. And so what happened is the judge went in and later reduced it to $5.3 million because the at $7.4 million is what the jury gave him. Those of you who don't know what that's called a remitter. Believe it or not, a judge can back down or increase the value of the jury's verdict. So for some reason the judge dropped it to $5.3 million, but it's a big win. It's a win. So let me talk about a couple of other things. Just very quickly, the notes about musical composition and the courts, what they're saying about this and what the law is about, what you can sue for, and how you can win and how you lose. Don't forget, the courts generally, and this is all general, every state's going to be a little bit different, but generally hold a common notes are not enough. If they have a common note, that's not enough to establish a copyright infringement. Because don't forget, there's only a limited number of notes in music. Also, they don't want to have a chilling effect on the music creation. But some of the issues you have to remember is if it's repeating, that's the one question. Is there the same notes in a melody? Are you using backup vocals? Is it the same beat? And then you look into the facts.
And the chord progression is important.
And then you look into the facts. Like in this case, the facts were, like I mentioned, they talked about this Marvin Gaye song as their inspiration and et cetera, et cetera. So there's a lot of facts that come in it, and they have experts actually that roll in about music.
Right, but I think the key issue is there is no bright line test, right? Because you could analyze any song just like you could analyze the chemical components of what's in a food product. I mean, how the notes are laid out, how long each note is, and you could basically make a bright line rule that says if these similarities are present, then there's liability, and if these similarities are not present, there's not. And the experts could tell you, break down the song and give you a thumbs up or thumbs down. But that is not apparently how the law works. A jury still needs to look at it, given all of those factors, and then make a decision, is this too similar or is this not similar?
Some subjective opinion from people who really don't know I don't know what it is, but I know it when I hear it.
Exactly.
Kind of a thing.
Yeah,
Exactly.
but to establish the infringement, two elements. You have to have ownership of a valid copyright in the work that has allegedly been infringed, and this is where it's so subjective, copying of constituent elements of the work that are original. I mean, that's like, what's constituent?
If I was on a jury, I would want to decide that case and get to listen to the song over and over again and be able to just make a decision.
Both songs are
Absolutely.
great.
Well, here's the buzzword: substantial similarities. Substantial similarity. We'll be right back. We're going to talk a little bit more about this and then move on and talk about guardrails.
Tweet us at Radio Law Talk.
And whatever you do, keep listening to Radio Law Talk on great radio stations like KAHI in Auburn. Go to the website, radiolawtalk.com. You can listen to the show there, and there's a lot of other good information, too. That's radiolawtalk.com.
We're talking about Blurring the Lines song, Pharrell and Robin Thicke's song, and the $7.4 million damages award that was reduced to $5.3 million by the judge. Well, it's up on appeal in the Ninth Circuit, And the interesting thing, what they're appealing, Denise, we were talking about on the break.
Yeah, well, first, during the litigation, Gay's commercial recording of Got to Give It Up was initially ruled inadmissible because the recording contains musical elements that was not found in the composition of the song in the copyright deposit sheet music. So they changed it somewhat. Marvin Gaye changed it somewhat from what he actually had copyrighted. So the song that we hear and compare it to, it really is not the song. But the judge later allowed for the Gaye family to do the composite sheet music and to create that exact music. And that was what the jury got to hear, which I haven't heard that exact version. I'm not sure that it's even publicly disseminated. But the jury did find that there was substantial similarity and awarded the Gaye family money. So Williams and Thicke now have appealed to the Ninth Circuit, and they are claiming that that there was initially a summary judgment done, and they're claiming that the facts, the causes of action that survived summary judgment and moved forward should not have survived summary judgment. So first, they're saying summary judgment should have been granted and or denied. And then they also assert that not having jury instructions requiring the jurors to disregard Gay's groove was reversible error. Now remember, groove, this is the kind of era or the kind of genre.
Watch her move.
Yeah,
watch YouTube. She's grooving right now.
And groove was kind of explains or kind of generalizes a genre that people were into
in the
70s, and that of course Marvin Gaye had made very famous.
Groove is the tempo, this walking bass line that they have, that bump, 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 bump. That's just
right now you're thinking of some guy with one of those big stereos on his shoulder. They used to hold up that are about the size of a Volkswagen bus.
Radio Raheem.
Yeah, those things are freaking huge. Anyway, don't forget just in February 1992, the Isley Brothers filed a lawsuit for copyright infringements against Michael Bolton, Goldmark, and Sony Music, and they won over $4 million in that case. So this happens all the time. Rodriguez is over here going, this is a really interesting part of law. He might be changing his law practice soon.
It is, but I would not want to be on the jury having to decide whether Michael Bolton infringed on the Isley Brothers. I would go to sleep. I would sleep through that trial. I don't want to hear any of that music.
All righty, there's some more. Is this Michael Bolton stuff? Yeah, all right.
This is Bolton here?
Yeah, and this is the song that was at issue. Love is a beautiful thing.
Right.
Wonderful thing.
Wonderful thing, right?
Yeah. All right, let's move on. People are sleeping out there because, man alive, we talk so much about that. We got to talk about guardrails on the highway. Now you think, oh, boring guardrails. This is really important. You drive down the highway and you see the guardrails. I've always wondered, you notice it's got that round part on it where they first start? Oh, and this lawsuit talks about some of that, where that's actually so you hit it head on. If you hit that head on, it deflects the guardrail, so it doesn't penetrate into your car and you get injured. But there's an interesting lawsuit that came forth between it's two guardrail manufacturers. I thought you think it's just some normal person, but a company by the name of Trinity, which makes these guardrails, and their competitor named Harman sued them under what's called the False Claims Act of the federal government. And the False Claims Act is very interesting, that people can sue on behalf of someone defrauding the government. The act imposes liabilities on individuals who defraud the federal government for four following reasons. Number one, whether there was a false statement or fraudulent course of conduct. Number two, whether or not that they made or carried out with the request of what's called requisite scienter, which, by the way, we'll talk about in a minute, and whether or not it was a material lie, and whether or not it caused the government to pay out more money or forfeit money, or to give a contract. And there's these different, I just want to go over these facts really quick, not the facts of the case, but just this basic law. So the requirements of the False Claim Act is you have to knowingly, actual knowledge, have reckless disregard, deliberate ignorance, and this, that's what basically this requisite scienter means.
An attempt to defraud.
Yeah, an attempt to defraud.
Yeah, so I actually practice a lot in this area.
Right.
And so most of these False Claims Act claims are actually brought by the government itself.
Right. But they don't have, the government doesn't have to bring it.
They don't. And that's what's interesting about this case. But basically, anytime you do business with the government, you have to be very careful, even more careful than if you're doing business with private parties, because of this False Claims Act. So every time you submit an invoice to the government, it has to be 100% accurate. And you can't do anything that could be construed as giving false information to the government in order to get money for yourself.
Which is broad. That's
right. So just a little bit of background about what happened here.
Sure.
There is a whole list of products that the government approves so that their agencies can go out and buy those products without having to go through the bidding process and all of this. And so this company, Trinity's guardrails, were submitted to the government for approval in order to be on this list. And so I don't remember what year initially the product was submitted, but they turn in this product and they say, we'd like to sell this product to the government for this price. Here's all its specifications. The government tests it, and it passes.
Right.
Right. It was 2005.
And they upgraded it.
Well, in 2005 is when they upgraded. They made changes to their product, but they didn't tell the government that they were making those changes. So they continued to
Not
sell
all the changes.
All the changes.
They continued,
Some, but not all.
Right. So they continued to sell this product, and then people were getting sued, as the government always gets sued, because when there's a car accident on the freeway, it was the guardrail was partially to blame, and one of the competitors sued and said, you have failed to tell the government about these changes in your guardrails.
Harmon's.
And for that reason, you have been getting money from the government under fraudulent pretenses.
Right, and there was the U.S. Justice Department did start a criminal investigation, but now that has been abandoned.
Right, and one of the other interesting things is the government itself is on the side of Trinity, and they're saying, we didn't think that these changes are material, and we don't think Trinity should be liable for this.
Right, so let's back up, just simplify. So Harmon's is suing Trinity on behalf, almost like on behalf of the government under the False Claims Act, and is claiming that you need to be sued because you're getting these contracts under false pretense. And that's basically it. And we're going to talk a little more about it. It does get interesting. We'll be right back with this is Radio Law Talk.
Radio Law Talk. I like that show.
Radio Law Talk, it's a show for your generation.
Wonder what generation that is. Not quite sure.
Whatever one you're in.
You know, it's interesting. We had our go to radiolawtalk.com. We got a killer new website, and we're talking to our SEO people. They're like, "Well, what's the genre? What's the generation that is going to listen to this? We want to know." And this is exactly what us, and we're sitting there. This is what we said. Exactly, cricket. Exactly. Crickets, yeah. He goes, "Do you know? Not really."
Well, we know there was that one woman in Canada, fairly attractive, that tweeted.
That's true.
Remember?
Oh yeah, that was marijuana.
She was in my generation.
That's right.
We have Pam from Eugene, and she's in my generation. So we have
Cal. Let's not talk about our generation, right?
But no, our generation is a fine generation. Were it not for our generation, Chris and Denise's generation would not exist. So it's got to be good, right?
Hey, Cal, is our generation awake yet?
Is it bad? Are you guys part of the greatest generation?
No, I'm part of the not that great generation. Our generation is waiting for the early bird special now over at Denny's.
That's exactly right.
We have a lot of law students that follow our show.
That's true. We do.
So there's a lot of generations in that group of people.
That's exactly right. Hey, let's follow up with this highway guardrail fraud case. This Harmon versus the Trinity Industries. I kind of looked up on. You got to go to Wikipedia, and I knew this was some sort of bad blood going on. Joshua Harmon is the one that brought this suit. Harmon's apparently, according to Wikipedia, let's see, let's go back. They bought out Trinity in mid-1990s until mid-2000s. Harmon bought Trinity Industry guardrail systems to install on state highways. After reporting over a year of no revenue, SPIG, which is Harman's industry, filed for bankruptcy in 2015. Now, this is all coming from Wikipedia. But then it goes through and says, in 2012, Harman filed a lawsuit against Trinity Industries after having previously been involved in an earlier lawsuit from 2011 in which Trinity sued Harman's company, SPIG Industry, for patent infringement. Harman paid damages and agreed to stop the production of early guardrail system designs. So guess what? This is a little bit of not too happy with one another.
These guys are what makes lawyers a lot of money. They hate each other, and they are doing everything they can to take their competitor down, including blowing the whistle to the federal government about bad things that each other are doing.
And tell them how they do that, Chris. He can do it on behalf of the government. He is in Harman, and who gets the funds? Harman could get the funds. Is that right?
He could get a whistleblower award. Absolutely.
Right.
Absolutely. Even though you're not damaged, you can recover collaterally by causing a benefit to the government and to taxpayers by essentially enforcing the government's rights for it.
So they pay lawyers to beat each other up. And as Mark Twain said, the purpose of one lawyer is to protect you from another lawyer.
That's exactly right. Those dang lawyers. Like my dad said, my dad was right. My dad was right, like I said.
Last man standing.
But here's the interesting thing. So, the original judgment was what? $663 million against Trinity is what the verdict was.
That's a good day for you, right? When your competitor gets a $600 and something million verdict against it, that's a great day.
Yeah. So what happens is the United States Court of Appeals for the 5th District ruled that Trinity Industries did not commit fraud against the United States and reversed the district court's $663 million judgment. Now let's all lay back. I want everybody out there to sit back in your chair, okay? Everyone sit back. Cal, I want you to lean back, Cal. Lean back. All right. Think about this. I just got awarded $663 million. Relax. Well, you walked out and you're at home and you're just like, oh, wow, what do I do? And then a few months later, zero. What interesting life. I mean,
but that's why you need to have a good lawyer that says, look, you just got an award for $663 million. They're going to file an appeal with these arguments. Your chances of losing are significant.
Or even if they're not significant, you might want to
try and settle it.
Right. That's exactly right. Hey, give us $50 million. And I behind the scenes, us lawyers know probably what was going on is they were discussing this is up on appeal, and we'll give you $50 million. I'm not saying that's what happened, but that's what happens. They could have talked about it, and that's a very difficult thing when you win like that.
Yeah, the company argued that the changes were not significant and they didn't have to notify, right? But the Texas jury awarded $175 million in damages, which was tripled because under the whistleblower statutes, damages are tripled. So in this, the jury saw that the Joshua Harman was a whistleblower and that he was doing good for the government.
Yeah, that still doesn't add. There was one other thing I can't remember. Okay, it was $175 million in damages. District judge upheld the verdict and added $138 million in penalties. So there's another reason it came up to 661. Right. 633 because it's 3 times the 138, right?
3 times the 175 plus 138.
Plus 138. So 3 times the 175 plus the 138.
Ooh. It's a music reference. Those are called treble damages.
Right.
Treble damage.
Right. That's exactly right. So, but I can just picture this, just living in the. Okay, see, do I buy the new yacht or the new G5 jet? Let's do the new G5 jet. That's $29 million. Oh, no, we got to stay up. We're bringing what's wrong? I'm bringing the G5 jet back because I just lost.
You don't get any money while it's on appeal, though.
No, you don't.
Yeah.
No, you don't.
But in my mind, I just spent that $600 million twice.
That's exactly right.
You could get money, but more than likely they asked for a stay of the judgment pending appeal, and usually it's granted. If you might have to post a bond or something.
You would have to post a bond.
Yeah, but the big issue, like Denise said, was in this case. There were some changes, but what Trinity said is the changes were so minor they didn't affect the case or didn't affect the guardrail system or its safety. And Chris, you brought up the most interesting part of this whole thing. Usually, who is bringing these cases is the federal government, right? And this time it's a private whistleblower bringing it. Look, I'm going to we call him a whistleblower, but really this is a couple of people that don't like each other that just decided to do this. But in fact, is this one of the largest verdicts in the history of, at least one of the 663 for a whistleblower? Yet the government was on whose side? On Trinity's, the defendant's side. Now, I'm thinking, why are they jumping on their side? And the government did do all these tests that showed that it was safe. And why is the government doing that? And I'm not saying, I'm not a conspiracy theory guy here, but clearly, what if the government said, you're right, this was not safe, and you bamboozled us, and we have guardrails like this installed all over the United States? What's going to happen to the federal government?
I'm going to get sued.
Hey, layman out there sitting behind the glass, what is going to happen to the federal government?
Well, the government's going to sue, so the government basically...
No, they're going to get sued by everybody that gets in a crash with
every
the guardrail.
person. And so my thinking is, too, there's another more subtle point, and that is it not in the government's best interest to have a vendor they can count on that meets their specs, so when they do a build, they actually have a supplier? I'm thinking if this guy takes this guy out and the other guy's already gone bankrupt, we have a problem when they start trying to build roads, right?
How about another subtle takeaway from this whole story? You ever drive, you're going up to Tahoe and you see people in Teslas and Bentleys and everything driving past you in the fast lane, and you're wondering, where does all this money come from?
Right.
These are guardrail companies. They build guardrails. They're suing each other for $650 million. There's somebody making a lot of money manufacturing guardrails.
Exactly.
Yeah, and after the Court of Appeals holding, reversing that decision, Trinity's shares jumped 11% in after-hour trading.
Wow.
So Trinity benefited a lot.
I wonder if us at Radio Law Talk, if we start buying Trinity stock, if that's like insider trading, now that we know everything.
I think we'll make more money suing them, won't we? I mean,
yeah, well, the three of us.
Given that we got all our information from Wikipedia, I think we're okay.
That's exactly.
solid ground, Chris.
I'm going to love it. From now on, the lawsuits come in. Who's counsel? Radio Law Talk. Instead of Chris Rodriguez, Denise Dirks, and Fred Penny as counsel, it's Radio Law Talk's the counsel.
Yeah, yeah. Before we talk to the court, Cal, are you ready back there? Is all the equipment set up? We're ready to go? Thank you, Your Honor. Go ahead.
All morons!
That's exactly right. Go ahead,
when I do a declaration for attorney fees, I now have to add that I am a co-host on Radio Law Talk.
That's exactly
Gives me
right.
instant credibility.
And that justifies your tremendous hourly rate. I won't even say what it is on the air.
No, when we roll into court now, they're like, you can hear the judge. Psst, that's Fred Penny, Radio Law Talk.
That's Lance Ito who said that, by the way.
Yeah, that's exactly right. Those who don't know that, isn't that the judge in L.A., the L.A. judge? So anyway, we've got
that
a minute.
was the O.J. Simpson.
Oh, that's
judge.
what I'm saying. In L.A.,
Yes,
the O.J. Simpson
absolutely.
judge. So we got about 30 seconds left. The next segment, we're going to talk briefly about Rhode Island, the state of Rhode Island recently passed a law that bans flame retardants in furniture after environmental health and firefighter advocates voiced concerns that the chemical in the flame retardants contribute to increased cancer risk and other health issues. We're going to talk more about that quickly when we come back, and these cancer-causing chemicals in your couches. I'm Fred Penny, host of Radio Law Talk. Call us.
Tweet us, Radio Law Talk.
And next hour, another case or no case. That's all coming up.
All around the world. This is RadioLawTalk.com.
Radio Law Talk keeps expanding. We're so excited to be with different networks around the West Coast. We have some big news next week. We're going to talk about it next week because contracts haven't been signed, but let me tell you, everybody out there, we are moving forward with Radio Law Talk, and we are moving into other states. So be prepared next week. We might even be on the air in
New York City.
Not yet. We're not back east yet, but we are on SRN. Thank you, SRN Satellite, for bringing us on into their family. This Rhode Island law that passed that bans flame retardants. Apparently, this type of flame it's called an Oregon O-halogen flame retardants, and the issue is those compounds are found in upholstered furniture and bedding, and basically it's to protect people and property from fire impact. It's kind of a flame retardant. They're now finding though that the chemicals in it are now causing cancer. And even firefighters are saying when they're coming into a fire and the furniture's on fire, they're getting exposed to that. And we were talking on the break, how do they get exposed to that when It's actually, I thought they've got masks on, but maybe they are getting exposed to it. So the big issue there is determining whether or not it's kind of a good, better, or best. Do you burn to death, or do you take out the chemicals that might cause cancer for you laying on the couch? Now, here's what the Rhode Island law says. It says, beginning January 1st, 2019, no manufacturer, wholesaler, or retailer may manufacture, knowingly sell, offer for sale, or distribute for use in Rhode Island any residential upholstered bedding or furniture which contains a certain concentration of organohalogen flame retardant chemical. So that is what is coming down. But then the issue is wow, are we going to burn to death now? So what I'm going to do a little bit different here is we decided to do something different. Chris, I want you to take the side of yes, why this is good, and then I want you, Denise, to say no, why it's bad.
Okay, so let me argue the point as to why this law is a good thing by looking at California. The state of California thought it was doing a good thing by having some of the most stringent consumer protection laws in the nation with respect to household furniture. And they said you cannot sell household furniture in California unless it can withstand a fire for 12 minutes. So what did people do that built furniture for sale in California? They put all these kinds of chemicals in it. Now, I mean, I promise you, I could probably throw my couch into the bonfire in my backyard, and it would never burn, and I could put it back in my living room the next day and sit in it.
And it'll probably have black smoke spewing out, and everyone will faint and fall.
But guess what? Now these studies are showing that women have higher levels of these chemicals in their breast tissue. Children have higher level of these chemicals in their bloodstream in California than in any other place in the nation. So
it was Governor Brown that enacted that.
And that's why I think Rhode Island's doing a good thing, because they're saying, look, the odds of you being in a fire are far less than you sitting in your couch. So let's have you be safe while you're sitting in your couch, and let's do less requirements in terms of how long your couch can withstand a fire.
Denise?
Well, the flame retardants do protect a lot of people. It's common for people to drop a cigarette or do something like that where they're on their couch. And if, in fact, the flame retardants work, then your couch isn't going to just blow up and kill you or start fires in your house. The fact that there's long-term adverse effects for these chemicals should be outweighed by the fact of how many lives it's actually saving. And maybe there is a better approach, instead of banning them altogether, but to really determine what's the level that's not going to cause these hazardous health conditions. That may be something that can be done as well.
So we got the pros and the cons, and now I'm going to come in and say, I say we strip the whole house of everything and we live on wood or live on dirt floors again.
Your Honor, I'd like to make a point here,
Yes.
and that is, how important is all of this to the people who suffered from wildfires and really were damaged by wildfires? To me, this is only a non-trivial issue when a child has a nightgown catch on fire or something like that. So this is a far-reaching governmental heavy-handed attempt to stop tragedy when we live in a world where things burn.
Hey, Cal, tell us what you really feel.
I'm just making a point.
But don't you think this ban is like too overly broad?
Yeah. So that's a good argument for you. Now the question is, and we do not make light of any of these issues that are coming up, but I wonder if there's a picture of a house burnt down and the couch still sitting there not burned. You know, that's the way you're saying the ones in California. They were hard to burn, but I guess you got both sides. But my play on this, and it was meant to be just a little funny, is everything's going to cause us cancer. Isn't that true nowadays? It's just, look at it again. We talk about our Prop 65 sticker out there in front of our building.
Mm-hmm.
Well, what do? Do you burn? Do you what? And I know one thing for sure. My grandchildren, my children, we were always careful to be. If you get like a little dress for your girl that's made out of Taiwan, or I'm not saying it's Taiwan, but I'm saying any of these countries that they have some issues, they'll go up. And you know what? Our law firm has handled lawsuits where children's clothes have caught fire and just burned them so quick because of the type of dress didn't have the proper flame retardants.
Well, how about make it a free market issue? In California, I could go to a number of furniture stores and get the fire retardant furniture, but also there are companies like IKEA, Crate and Barrel. They don't put the fire retardant on their furniture. I honestly don't know how they're complying with California's regulations, but I'm sure that they do, or they wouldn't be allowed to sell them. But they have gone away themselves so that they can market their products as not having these chemicals in them. And so why not leave it to the consumers? If you want to buy one that's not going to catch on fire, buy it over here. And if you want to buy one that might catch on fire but isn't going to fill you with chemicals, go to IKEA.
Trusting the responsibility of the consumer? That's a radical idea.
Yeah, that's exactly. Hey, let me just read the pros and the cons from when it comes to the professors or the engineers. According to Miriam Diamond, professor of geology and chemical geography and chemical engineering and applied chemistry at the University of Toronto, she says, or he says, Miriam, is that a man or a woman? I don't know. It sounds like it's a woman's name, but there is, quote, there is a sufficient body of knowledge to conclude that all of these flame retardants, because they are semi-volatile organic compounds, will tend to migrate out of the consumer products in which they are present. And they talk about flaking off and stuff like that. Are present in additive forms resulting in human exposure. The inevitability of the human exposure combined with the evidence showing that these compounds have toxicity leads to the conclusion that all of these organohalogen flame retardants present in consumer products in additive form pose significant risk to human health. That's the pro. That's the pro to take it out.
I'm not going to let my 10-year-old sleep face down with his face buried in the couch anymore.
That's exactly right.
After today's segment.
Now, Thomas O. Solomitz, a toxicologist and chair of the North American Flame Retardant Alliance Advisory Council, whatever that is, argues that there is no significant evidence of a link between fire retardants and long-term adverse health effects to firefighters. He also noted that the U.S. Environmental Protection Agency is assessing the flame retardants now and notes that these are potentially premature bans. And basically let's wait and see what the EPA says.
Right.
So anyway, so there's a couple of arguments. It's always good, better, or best. I think they're both good things, but which one is the most important right now?
And his hold in the argument that you just read was no danger to firefighters. But that's not who we're talking about.
That's exactly what I noted that down. Yeah. But firefighters are one of the ones that are bringing this forth, by the way. It is the firefighters and some environmental protection people. It's the firefighters. There's some associations that are fighting this too. They want this banned because it's harming their when they're rolling in on a fire and these are burning, it's harming.
We're sure it's not because of the brand new lazy boys that are laid out in the upstairs rec room at the fire department.
It could be. It could be. That could be flaking off. So anyway, that's interesting. So we're about at the end of our second hour. Next hour is going to be kind of an important thing. We're going to talk about the Las Vegas shooting and how it applies. The laws apply in that issue. There are so many issues about who's liable, who's going to be at fault. There's already 3 lawsuits filed. There's going to be more. How does this come down? How do you prevent such a thing? We're going to talk about bump stocks and talk about whether or not they should be held liable. So join us in the next hour, and then we're going to do a case or no case. That's very important. So hour 2 is done. I'm Fred Penny, your host. I have Denise Dirks. I have Chris Rodriguez with me. We'll talk more about the Las Vegas issue in our next segment. We'll be right back.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated. The following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Welcome to Happy Valley. This is our third hour of Radio Law Talk. I'm your host, Frederick Penny, with Denise Dirks to my right. And to my left, Chris Rodriguez, our Prince of Harvard. Behind the glass, our producer, 3-time Emmy Award nominee.
Often nominated, but never a winner.
Cal Hunter.
Cal, you're a winner in my book.
Thank you.
And then we've got our call screener, Seth Madden. We're having a lot of fun this third hour. And it's not what we're going to talk about. It's not a lot of fun, but we've been having fun the past few hours. We're going to talk about the Las Vegas shootings and liabilities. We were going to talk about it last week, but we decided we're going to wait and let it settle down a little bit. But it's really important to talk about liabilities and who's going to be at fault and what lawsuits are coming down the pike, because it's very interesting. And we're going to talk a little bit about bump stocks and bump stock manufacturers being sued. And we're going to have Seth Madden walk in here and teach us about bump stocks. If you want to call us, because Seth knows a little bit about it, you want to call us, call 855-LAW-RADIO or tweet us at Radio Law Talk. Welcome K-High. K-High is with us live. Thank you, KRAC Crack Radio in Red Bluff. They are our sister station or our mother station that produces this program, and we thank them very much. Remember we're talking about general topics of law. If you need any legal advice, seek an attorney. Even though we're brilliant people, we believe, at least we think we are, unfortunately, it's important to get a lawyer because there's so many details in every case and every lawsuit. Our great general knowledge here is not going to necessarily help you. But if you have questions, call in. We have Denise is a family law attorney. I do personal injury, and Chris Rodriguez, who knows what he does? I'm not quite sure.
He does a lot.
Civil litigation.
No, he does. He's employment law. He does corporate, all types of corporate litigation and corporate law
And business related.
Anything business related, he's in there. And then we're missing Todd Cunin, our cat
lawyer.
Cat loving, not make my bed lawyer that is single, and we're still going to try to hook him up.
It's hashtag Todd Coonan. I love cats to date.
To date? Oh, okay. And then the best.
That's the whole hashtag?
That's close enough.
My goodness.
We better thank our law student, Amanda Purcell from University of San Diego Law School. What we do here, folks, is we have second and third year law students do research for us, and we love doing the research. I'm getting texts already. My son-in-law plays football, by the way, and I'm not going to get into my personal stuff. My son-in-law plays football. He's a phenomenal football player, and he's playing on national TV right now, and they just tweeted me he is absolutely tearing it up. So apparently he's playing live. They're playing Mississippi State, and my son-in-law, I hope you're doing well, but everyone's texting me he's tearing it up, so I guess he's doing well, but we'll be watching that later on.
When they say tearing it up, hopefully they're not talking about his knee.
No, they said he's doing really well. They said he's actually a linebacker, and he's doing a good job. But here's the interesting thing we're going to talk about more than anything is, guess what? We're going to talk about, what is it, Cal? Case or no case?
Are you ready to?
We're not ready for it yet. But case or no case is what we're going to talk about.
And I told you this is the smelly segments of case and no case. This is the deodorant hour. So I just want to give you a warning.
Yeah. So I did. Okay. So I didn't finish. But my point is we let these law students roll in and do great research for us. We give them $100 scholarship, and we mention the law school. And this one's University of San Diego School of Law. And
Amanda Purcell, she did a great job for us. She did 4 different topics for us in our 3-hour show format. And we just want to shout out thanks to Amanda Purcell.
Yeah, usually I do 3 topics. She nailed it in 4 topics, and you did a good job. And thank you, actually, my son. I'm going to thank my son, Garrett Penny. He is a law student, a second-year law student, and he oversees this program. And we have law students from all over the West Coast doing this. And you know what? If you're a law student and listening, and you want your law school,
contact us at info@radiolawtalk.com.
That's exactly right. All right, let's roll into the case or no case. Well, this is a great segment we do usually every hour or every other hour, and it is Cal Worthington. Oh my gosh.
Well, it is the voice
Cal
of Cal
Hunter. Yeah. By the way, that is Cal. You might be doing some of that.
I do the television voice for Cal Worthington Ford in Long Beach.
There you go.
Freeway exit 405 Long Beach.
There you go. Thank you. You got a plug for Cal? Did Did you know
Were you the voice who said Cal Worthington and his dog Spot?
No, that was actually Cal himself, who lived on a ranch in Orland up in Northern California when he did a lot of his TV spots in his later life before he passed here fairly recently. What a great story. He has a book about his life. You should read about this man. He is really fascinating character.
And congratulations, Cal. The producers have hired Cal to be the voice of Cal.
To do the TV spots. Yeah.
That's
great.
So what a great opportunity. Tells you who we've got, the superstar. If we're not nationwide one of the biggest radio shows, it's not because of Cal, because we got the superstar there taking care of us.
I know when he turns his mic on and he speaks, I feel like we're a bunch of sixth graders, missing layups on the playground, and then LeBron James steps on the court, shoots a couple jumpers, dunks a couple, and then goes back and sits down and watches us play, with ourselves.
I tell you what, I missed your sports analogies. I really did.
Well, there you go.
It's good to have
there's
you
one
back,
right there.
Chris.
Just the opposite is true. I'm the sixth grader, but thank you very much. I appreciate
Go ahead, Cal. Let's do case or no case.
Yeah, I think
so
maybe-
what he does, I'm sorry, Cal. I keep interrupting you. We do not know about this, huh, Cal?
Nope.
You have not mentioned these cases.
Nope.
They're not pre-recorded. They're not rehearsed. And we're just doing this off the hip.
And the first case or no case, by the way, was about a prisoner suing because of a lack of deodorant in the prison. And it was a case that didn't go that well for him. But
Now it's time to play Case or No Case.
all right.
Are they chanting Fred?
No.
Case.
Oh.
Case.
I'm pretty sure Fred changed that. We got to look into that.
An inmate in New Jersey. Once again, I take you to the deep, dark, dank walls of the U.S. prison system, because some really interesting cases come out of this here.
They have all the time in the world to bring cases.
Apparently, this prison in New Jersey has its food catered by the same people who cater to sports stadiums. The Aramark company, I think, is maybe that's one of them.
Huge company, yeah.
But Aramark is huge, yeah.
Yep.
Uniforms, stuff. So the guy is saying that there's price gouging going on for prison meals. Let's see if I can. He says $5 for protein bars, $4 for geisha tuna, $2 for an orange soda. I'm getting ripped off here, and I want to do something about it. And so he decides to file a lawsuit claiming price gouging for prison food. When asked what he wanted, he said, "I just want good food at a fair price." Okay, well, so now, Fred, I'm thinking to myself, don't we all, right?
No.
So, Fred, you're the food guy.
I tell you right now, the problem is right when you started saying this, I went, whoa, deja vu, because we pay at a certain arena prices for food that are absolutely outrageous. Our law firm, we do okay, I'm going to say, and we have a suite at an arena, and the prices are outrageous. I feel for this man.
So 5 chicken wings are like $100 at their arena, right?
I feel for this man. I'm with him. I wish he would have called me. That case I would have taken, where before I wouldn't have taken the other one. Okay, so the question is, can he? Well, there's an issue if he's in prison. That's the first thing. But do they have a duty? Because okay, let's back up. Cal, what you're talking about is they get the free food, but I'm assuming you're talking about when they can go off on their own. They got these little stores in the prison. They can buy their own stuff.
Commissary food.
Right. So he's saying that's too high. Mm-hmm. I think he's got a case because I think they can't price gouge even the prisoners. They even have some rights, believe it or not, under the Constitution. I'm not a constitutional law lawyer. I don't know the law on this, to be honest with you. I'm going with my gut feel, and I'm going purely with what a jury's going to do because I feel for him, because if I'm a juror, I'm giving him everything he wants. I'm tired of being price gouged myself. And you know, we got 15 seconds to go, so we're going to come back and finish with case or no case and talk to Denise and Chris.
I'm going to Google it and give you guys the right answer after the break.
No Googling, no Googling.
And tweet us at Radio Law Talk.
We'll be right back on RadioLawTalk.com with more Case or No Case. Are listening to RadioLawTalk.com.
So we're back talking about case or no case, price gouging in the prisons. I am purely emotionally saying case, purely emotional. Rodriguez, I guess.
So you're thinking, Fred, that yes, a guy in prison has the right of course, you can sue anybody for anything, I suppose, but has the right to say, look, when we order food from the outside, you're ripping me off. A guy who's in prison for larceny is saying that Aramark.
No, I did not say he has the right to do that. I'm on his side just because I'm tired of being price gouged.
Got it. So is it a case or a case?
I'm going to say I'm going with case just because it's all feelings, no logic.
Fair enough. Chris Garcia.
I'm going to say no case. However, I'm going to caveat that by saying if there is evidence that these items are being sold for much higher than where they would be sold at like a gas station or something like that, then possibly yes, case. Is that have I gotten off the fence enough for you, or would you like me to just be more unequivocal?
Could you please ride the middle, please, just a little more? So if a guy came to you, a prisoner came to you, and this was your area of expertise, would you take the case?
If he's paying by the hour.
I would not take that case. I would not take that case. No way. Nope.
All right. Denise Dirks, case or no case?
Well, first, price gouging is when a seller spikes the prices of goods, services, or commodities to a level much higher than is considered reasonable or fair, and it's considered exploitive, potentially to an unethical extent. So if he can show that Aramark Company...
if it's Aramark. We don't know if it's Aramark.
Oh, what? Okay, sorry.
I'm just pulling... I mean, no, they're a big vendor. Because
the catered food company.
Yeah, I'm thinking of garlic fries at the Oakland Coliseum. So, right.
Yeah, no. If he can show that the catered food company is selling to other institutions, schools, whatever, at a much less price than they're selling to the prison, then I think he might have a good case.
If this was your area of expertise, would you take the case?
I would...
Hourly or percentage?
Well, no, I would not take it on a contingency for sure. But
which means I don't believe in this case, but I'll take it.
Yeah, I would say that I wouldn't take the case because you did not give me the facts that I needed to determine that it would be successful.
Well, now it's time for our reveal. If I had envelopes, I would give
Where's
you an envelope.
Where's the drum roll? I want the drum roll.
All right, now
drum roll or something.
Let's see. For this, I think for this case, I think I'm going to go with this.
There we go. That's a good one. That's a good one.
That's what we'll do.
Taps.
Okay. Case or no case? There's price gouging going on at the Orange County facility, Mr. McWillis claims in a Manhattan federal court. The 54-year-old McWillis has been cooling his heels in the Goshen, New York jail on a grand larceny charge since April 10th. The jailbird, acting as his own lawyer, so he couldn't get somebody to take it.
Yeah.
The jailbird, acting as his own lawyer, isn't pleased with paying $4.94 for a protein bar, $3.69 for geisha tuna, $2.05 for orange soda, and $3.61 for a Big House summer sausage.
I'm feeling it.
Big House? They sell a Big House summer sausage?
Well, in the prison, of course, a Big House. What other kind would they sell?
Cool and unusual marketing.
Apropos.
He says inmates and their families cannot afford the price of the commissary items, and other state prison commissary price lists are much cheaper, he says, have more variety, and are better quality stuff than in the Orange County jail. So the answer is yes, ladies and gentlemen. It was a case that he filed by himself.
Yes.
And
but did he win?
We don't know yet.
Wow.
It's just the let's see what did the judge say? Judge, he wants $300,000 from Aramark and $100,000 from the jail. Aramark for price gouging, Denise, what you described, and $100,000 for the jail to quote allowing it to happen. Come on.
Well, that's the nature of price gouging. It has to be an active participant, not just an allowing it to happen.
So the answer is yes, it is a case, but I don't give it a lot of hope for making its way through the courts based on what you guys have said. But that's just me. I'm no legal guy.
Right.
I'm just a radio guy.
Thanks, Cal. That was interesting.
There you have it, ladies and gentlemen. Case or no case?
Fred.
How do you segue from that into the serious issue of Las Vegas shootings? I just don't know how to say. How do I segue? What's the segue?
Well, there's 3 suits that have already been filed in that Las Vegas shooters matter, and they're 3 very different and distinct types of lawsuits.
You take Denise's approach. You just go for it. Just go for
just
it.
roll into
Yes.
it. Roll
Thank you,
into it.
Denise. Go ahead.
Hashtag direct Dirks.
When in doubt, jump in, right?
Yeah, no, you're exactly right. Just everybody knows the facts. I don't know if we want to go into details, but there was 58 people that were fatally wounded or fatally that passed away, and I don't know how to say it in a nice way. Over 500 wounded when this crazy guy is in the Mandalay Bay Hotel, breaks out the windows and starts shooting them. Now he's shooting them with a legal semi-automatic weapon and a legal bump stock. Now, what he's got is he's got what's called a bump stock that makes it so it can shoot faster. So what we've done is we've decided to bring in our little boy in there that is our call screener that knows about, believe it or not, he knows quite a bit about rifles, grew up having rifles, and knows quite a bit about bump stocks and how they work. So we're going to have Seth Madden come in. Let's give the applause. Find an applause. Bring Seth in and tell us what a bump stock is and how it works in detail. He's rolling in. Wait a minute. Let me tweet this. I'll have to be the tweeter guy.
So
Okay.
the first
You're telling me there's a chance.
So one of the first lawsuits involves plaintiffs against bump stock manufacturers.
Right, and you know what the best part of it? Let me tell you what's happened, those of you who aren't watching live. Seth is the one that holds up our cue cards as to how much time we have. He walked in, sat down, put his headphones on, and held up the 1 minute mark.
Right. This is his big chance here on the radio. He gets the headset on. I've been waiting for this all day myself, and Fred brings him in with a minute,
Yep.
and then Fred talks for 45 seconds.
Yeah, I'm gonna talk
So
for
I'm going
another
to
30
filibuster so that we can wait and actually have Seth
He's
talk
got 30
after
seconds.
the
Wait a
break.
minute, let me take a picture of this 30 seconds. He's now holding up the 30-second thing. Okay, I'll tweet it out.
Let's flip it for 15.
Tell me when it's 15, and then see what you know is we have cue cards that we have to go to break. And
Hey, if you have questions for Seth, call us at 855-529-7234. That's 855-LAW-RADIO.
Okay,
we'll
Seth,
be-
you got 10 seconds. Go ahead. Tell us about bump stocks.
Pass.
Before we kick you out of here.
all right, we'll be right back. Talk about bump stocks. I'm Frederick Penny. Hey, Cal, end us.
Radio Law Talk. I like that show.
Go to the website, radiolawtalk.com. You can listen to the show there, and there's a lot of other good information, too. That's radiolawtalk.com.
We're back talking about the Las Vegas shootings and the legal implications from such. Seth Mann's in here who knows a little bit about bump stocks. Tell us about bump stocks and how they work.
Okay, they're essentially a butt stock on an AR-15 and an M4 style rifle, and the way that they operate is it's one piece, so it'll be the butt stock attached to like what people refer to as a pistol grip, and so that whole piece is off, and with that piece off on the rifle, there's like a little square block. And the little square block has grooves in it, and that is actually where the pistol grip will attach to the rifle. So you screw that little plastic block in right below the trigger, and then there's a thing called a buffer tube, and that's the spring, or inside the buffer tube is a spring that allows a semi-automatic rifle to work. So when you pull the trigger, the bolt carrier goes back, and it's forced back forward with that spring. Okay, so that tube where that spring sits in is where the bump stock actually slides on. So it slides onto that tube, and it slides onto that little block. And so then there's your trigger group, or your trigger area. There's like a little cutout, and then your trigger sits down inside of there, and that's any other
Where your
gun.
finger is.
Yeah, where your finger goes to pull the trigger. The bump stock actually goes forward it sits right about the middle of that trigger hole. And when you get a hold of the pistol grip, you lock your finger in on the bump stock on this plastic piece. So your finger is not actually on the trigger at all. And it sits probably a quarter inch, an eighth of an inch in front of the trigger. And so what you do when you shoulder the rifle, you actually just pull the rifle forward. And when you pull the rifle forward and you keep your hand locked on that pistol grip and your finger in place, it'll pull the trigger for you.
Well, your finger's hitting the trigger.
Yeah, so your finger stays locked in place, and when that action, it's like you're separating the rifle, and it'll pull the trigger for you. So essentially, what you have to do is you have to keep forward pressure on that rifle. You keep the rifle pushed forward, and the recoil keeps coming back. So you have to be able to withstand that recoil, and you just keep your finger locked in place, and it just continues to push the trigger.
So it changes a semi-automatic into an automatic weapon.
No,
No.
it does not.
Okay.
So
does it do then?
It allows rapid fire of a semi-automatic weapon. It
Okay,
does not
got
change
it.
like the rate of fire. So like if you were to sit a bump stock rifle and a fully automatic rifle right beside each other and you were able to pull the trigger, you would notice that a fully automatic rifle actually operates a lot faster than a bump stock does.
Got it.
Yeah, and a bump stock, it's actually, just think if you had a finger that you can pull really fast. If you had a superstar finger, you could probably, but the bump stock's doing that for you.
And so you can eliminate the butt stocks, and you can actually do it with your belt loop. The same style of fire. You wrap your thumb through the trigger hole, and you lock it into your belt loop, and you just keep forward pressure on the rifle, and it will do the exact same thing.
And the bump stock was invented by a military veteran for people who had physical handicaps, so they could hold this hand in place and pull the weapon forward and get fire out of their weapon, and again, by a veteran,
right,
for people who were not physically able to fire.
And he's made millions and millions of dollars. I think I read
30.
something where in 1 year he had $10 or $15 million in revenue off of sales of bump stock.
Slide Fires, the company, received more than $10 million from the sales of bump stock in 2010. 2011, Slide Fire sold upward of 35,000 units in 2011.
So what they leave
But they're not
out-
selling to the military.
No, they're selling to everybody.
They're selling just to
And it
persons.
is-
To legal gun owners.
Yeah. And it's completely legal as of right now. It's completely
It
legal.
has the ATF stamp of approval on it, and there's actually a couple different companies that build them, Slidefire being the number one, and theirs is actually a really expensive product. I think it's about a $250 piece add-on to the rifle, and then there's another company called Bumpfire Systems, who they actually sued each other, believe it or not. Bumpfire had to go out of business for like some kind of period of time, and then they came back in business, and their bump stock piece is like $85. So
okay, thanks, Seth, for coming on in, and go back out there. It looks like the phones are ringing. You better get back to your job and go hold your card.
Seth's going to the shooting range now.
Yeah, but that's interesting. So what the lawsuits that are being filed? There's a number of lawsuits. Here's the potential defendants. Okay, Mandalay Bay, MGM.
The parent company.
Which is the parent company. And by the way, the property in which this concert was being held is owned by MGM or an affiliate of some sort. Live Nation, who put on the concert. And also there is a product liability lawsuit being filed against this Slide Fire Solutions for emotional distress. So here's what's interesting. A couple of things that are interesting. And we've gone over this. There's federal law and state law. Chris, go over really quickly for our listeners, just very briefly, the difference between federal and state, and why they're going, well, why are you filing in state? As when I first started law school, I was still confused about this, and I learned through law school why it's different. So there's federal laws and state laws, and federal court and state court.
Right, and federal laws. Federal powers are limited by the Constitution, so the federal government can only regulate certain things. Most of the laws that we deal with as consumers or as people living in this country are state laws. But there are federal laws that deal, for example, with firearms and what you can do, what types of firearms you can sell, what types you can't sell. And in particular, there are some laws that protect the manufacturers of firearms so they cannot be held liable in situations like this. And so you notice nobody is suing the manufacturer of the gun. They are suing the manufacturer of the bump stocks, which Seth just explained what those are, under the theory that they are not covered by the federal exemption and the law that says you cannot be held liable as the manufacturer of these things.
Yeah, go ahead.
If bump stocks are considered guns or gun accessories, then they are going to be exempt from being sued, and that's going to be the issue at this particular lawsuit.
Right, that's exactly right. Now, another important thing in the state courts of Nevada, in different states, they have different types of laws. One's called comparative negligence, different types of negligence. First, you have to show there's a duty. Is there a duty to do they have a duty? Let's say Mandalay Bay. Does Mandalay Bay have a duty to these people? Does anybody have a duty to make sure these people are safe? What's interesting about Nevada is they're a contributory negligence state. And in contributory negligence, there's comparative and contributory. California is comparative. That means no matter what percentage at fault you're at, you have to pay that amount. An example: if you get hit with $100,000 verdict, and you're only 10% at fault, and Joe Blow is 90% at fault, you pay $10,000 to the plaintiff. In contributory negligence state, which Nevada is, you have to show you're more basically 5150. So in other words, it doesn't have to be exactly 5150, but you have to be more at fault than the other person. So if one person's 49% at fault, and let's say the guy who's the shooter, what was his name again?
Stephen Paddock.
Say Stephen Paddock, the jury finds is 51% at fault, and Mandalay Bay is 49% at fault. Then under the contributory negligence state and laws, they pay nothing. Mandalay Bay pays nothing. So that's interesting to note. In Nevada, it's a contributory negligence state. If that was California, Mandalay Bay is paying 49% of the damages.
Right.
So
it's also interesting to note that Paddock's brother has fired his own preemptive strike by beginning to give away. He hired a law firm to give away some of the funds of his deceased brother, and he just fired that lawyer and is now hiring another one to handle that. So he's being preemptive in distributing those funds to the victims of the shooting.
Which is what you would expect them to do,
Right.
because there's no way. I mean, people are just going to be tied up in legal battles over that estate. I figured that probably would happen because that money, the family's not going to see that money anyway.
Right.
And they have these good victims funds now where 100% of the proceeds are supposed to go to the victims. In fact, I think the mayor of Las Vegas has been championing one particular charity, and you donate to that charity, and I think that they come up with some fair way to distribute that money out to the victims and their families.
It's called Victims of Crime in California. And actually what it is, for example, say a drug dealer, they catch him with a new boat and $100,000 in cash. That goes into that fund, and that goes toward those people who are victims of crimes to pay their their special damages, not general, not their pain and suffering. It just goes to pay whatever their expenses are in California. I don't know what Nevada is, but that's available. But here's what's interesting also. In Nevada, the first issue you have to ask yourself as to who's at fault, and we're laying all these different people out, and there is an issue of product liability with bump stocks, and they're being sued, but the issue of whether or not Mandalay Bay, MGM, Live Nation, because apparently things were set up around this. Don't forget, everyone thinks they're all killed. Everyone that died was killed by a gunshot. Some of them were trampled. And so the issue is the fences around there, was there enough, did they hold them back? There wasn't enough exits or an exit that is reasonable enough to accommodate people leaving. Is there a duty of care on behalf of Mandalay Bay, who has a duty of care obviously to who? Their patrons or people on their property, but what about people that aren't on their property? The judge in Nevada decides if there's a duty. In other states, the jury decides that. But a judge has to decide first. In Nevada, is Mandalay Bay, is MGM, is Live Nation, do they have a duty to these people? And if that's no, it never gets to a jury. And then the jury decides whether or not
So they treat the duty as a matter of law.
That's exactly right. And so we're going to talk a little more about this when we come back and talk in more details about who may be at fault for this Las Vegas shooting. This is an unfortunate thing. Tweet us at Radio Law Talk or call us at 855-LAW-RADIO. We'll be right back.
The discussion continues now on RadioLawTalk.com.
Who's going to be held liable for these Las Vegas shooting? Negligence, duty, breach, causation. And then whether or not there's intervening acts. There's a lot of things that I'm skipping over quickly because this is 3 years of law school. But Chris, duty, breach, causation.
Right. Okay. So one of the basic theories by which people are found liable to others when they get hurt is the theory of negligence. And so what negligence means is that you have done something that is below the standard that is normally acceptable in that industry or in society. So you have failed to keep an area as safe as you should, or you have driven in a way that is reckless. So whatever the conduct being looked at is, in order to be liable to that person that you've hurt, you have to have done something below the normal standard of care or competence.
But first you have to get to duty.
But and then if you have done that, and you can analyze these in whatever order, But you also have to have a duty to the person that you've hurt. So here's an example. Let's say I manufacture a bumper that is faulty, okay? And the car that has the bumper on it is driving down the road. It hits somebody from behind. That bumper falls off of the car and travels across the sidewalk and hits somebody and knocks them down. Okay? You probably had a duty as the manufacturer of that bumper to the person who got knocked down, because it is foreseeable that based on the defect in your bumper, things like that could happen. But what about the person who was supposed to meet the pedestrian who got knocked over by the bumper and killed, and was supposed to shake their hand and finalize a business deal and get $1 million from that person, and they lost out on $1 million because your bumper knocked them over on the sidewalk?
No duty.
No duty, because it's not foreseeable that your bumper caused somebody to lose out on a business deal.
Right,
so that's basically what we're talking about.
Now
here.
let's apply that to this. So we got to be careful about opinions, because there's a lot of facts. We're talking about the facts. There's a lot of facts that are being thrown around. Clearly, if there's a fence that is all the way around, was there 20,000 people, and there's one entrance or small entrances, or there's not enough area for people to exit quickly, whoever promoted the concert, Live Nation, whoever owns the property, MGM, or one of it's called you can know this, you're more real estate, it's a REIT, which is a real estate investment trust, owns the physical structures and the land that it was on, may be held liable. I think that is a bigger possibility of liability of that company, rather than the issue of, a guy's shooting out, are we liable for that guy shooting? If I'm the lawyer, I'm jumping on that first.
Right, there's a question of duty. So on the fence, and the people had came to the concert, and they've erected this fence around the entire concert. Whoever put the concert on and decided to have that fence there,
and took the tickets,
they owe a duty to those people. There's no question about that. The question is, did they fall below the relevant standard of care by putting that fence up? They're going to argue, we wanted one entrance and one exit so we could keep these people safe from things that might happen on the outside.
Or to control entrance on the case of, did they buy a ticket? Remember Woodstock? They started off trying to collect tickets. Next thing you know, 150,000 people, no tickets, everybody goes broke.
Sorry, Cal, we don't remember that.
Or there's rioting.
That was your era.
Yeah.
It's like we know you were there, and that's what you did, but we don't remember that. But then my argument is, don't forget, I'm the plaintiff's lawyer. This is right up my alley. Well, my argument is, okay, hire more people to do tickets and hire more security and have 5 entrances, and there's these exits that are supposed to be manageable. And you know what? Guess what? Then here's what's coming down the pike. Live Nation then cross complains against the city because they didn't have proper streets to get people in and out, and this and that. This is going to be a myriad of lawsuits. Everyone thinks, oh, it's just Mandalay Bay. It is going to be the ultimate complaints and cross complaints. And here's what's interesting, Denise, and you brought this up. You're like, look at this. There's already lawyers out there pretty much saying, what did the lawyers say? And I'm not
first thing, if you Google it, you're going to get a law firm out of Vegas that's already saying, hey, if you were there, or you were injured, or you had a family member injured, and so there's a lot of advertisement already going.
Yeah, you got to be very careful. In California, the ethics rule, you cannot go out and solicit like that. I mean, it doesn't mean you can't talk about it like we can and do that, but you can't walk out and actually that's not true. Let me back up. In California, they now have a law. You can send something and tell them that, but you got to say it's advertisement. And so there's all these little details you got to be very careful.
And can't be deceptive. It's under the Business and Professions Code. It has to meet certain standards.
Right. So everybody's locking in on this right now, trying to pull these cases in. But there's going to be a lot of liability. And here's the other thing in a lawsuit in personal injury. Those of you out there, here's the key: the person you're suing, do they have money? Because there's a lot of people that are injured in accidents. If there's no money, so what? I mean, you lose your leg, your family member dies, you're suing an old grandma that has nothing. There's nothing there.
Right.
There's money here, and that's why everybody's hawking in on it, trying to say, okay, let's go for this.
Well, it is an interesting question. I think this is the most interesting thing in terms of kind of textbook law school type issues. This hotel, the Mandalay Bay, let's say that they were negligent by not checking on this guy in his room for 5 days or however long he was there, by letting him use a service elevator if that's in fact what happened, by not taking the reasonable precautions. We talked about this issue of duty. The people that were shot were not patrons in their hotel. They were at a concert down the street.
Well, they could have been, some of them could have been patrons.
Well, maybe, but where they were shot was at some place down the street. So as a legal matter, was it foreseeable that somebody would, because of the lax security measures at the hotel, be shot 3 blocks away? Is it more like you got hit by the bumper walking down the street, or is it more that you were going to make a business deal with the guy who got hit by the bumper? How far attenuated down the chain of causation are we going to get to allow you to legally collect on that?
Now I'm going to step aside and say politically what's going to happen and emotionally. What people don't realize out there, and us lawyers, we know this, we're talking facts and we're talking the law. Now there's the emotional part you have to fight at the jury. And here's a judge that's going to have to decide the duty. That's the first thing a judge in Nevada is going to decide is duty. And if you're the judge saying there's no duty of all these people, what's going to happen politically in the backlash of this judge? I hate to say this, but the judge has to do what's right under the law. But politically, I would hate to be the judge on this. I would say pass, because no matter what the situation is, if they say there's no duty here for the hotel, Live Nation, MGM, or anyone, and then it gets thrown out and never even gets to the jury, that judge is going to have a lot of
there's
backlash.
precedents. In Nevada, the Supreme Court of Nevada issued a ruling in Smith versus Nugget case and decided that the man who was shot in the parking lot of the casino, the Nugget Casino, that there was no duty. In fact, that's exactly a precedent, I think, in this case. I mean, there's no duty to protect somebody in a parking lot from somebody being shot.
Here's the question I would ask. There are very smart people that are doing this, certainly after the shooting, but even before the shooting, that have thought about this scenario. These hotels this has crossed their mind before. They might have hoped that it wouldn't happen or thought that it wouldn't happen, but they have certainly contemplated the possibility of somebody coming up into the high-rise, breaking out a window, and shooting down.
And guess what? Everybody's pointing fingers. Wynn, what did Wynn say? Wynn's like, well, we wouldn't have done that. We wouldn't allow that in our hotel. I think Chrissy said the government's even now saying, hey, that maybe there's some issues here.
Right. Well, what Wynn said was, if in our hotel, if somebody comes in and checks in and they have the do not disturb sign on their door for more than 24 hours, that's a red flag, and we go check that out. Well, I've stayed in a lot of hotels. You guys probably have too. I make my room a disaster when I stay in a hotel, and I don't even want to burden a cleaning person with coming in and having to deal with that. I'll put the do not disturb sign on my hotel for the whole time I'm there.
The question is,
you're going to be a first suspect.
I might have to.
So the question is, do you have a cat on there with a bunch of all the covers thrown off like Todd Cunin?
Usually Todd Cunin is with me.
Oh, there you go.
With the cats.
With the cats. It's me, Todd, and the cats.
Well, you know what? This is such a huge topic. This is not a 1 hour, 45-minute discussion. There's so much to talk about. We'll follow up with this next week. Next week, we're going to talk about the fires up in Northern California and how that affects liability, because that's going to be affecting liability as in who's going to be at fault for the fires, the deaths, the damage, and the destruction.
And emotional distress, too.
Yes, that's exactly right.
Definitely going to be a part of it.
But Denise, you're going to thank someone again. Who are you thanking
yes.
again?
I want to thank Amanda Purcell from the University of San Diego School of Law for doing our research today. She did a great job, and we thank you.
I'd like to thank Cal Hunter. I'd like to thank
Cal
Seth,
Worthington.
Seth for stepping it. Yeah, I've said a few wrong words today. My co-hosts Denise and Chris, thank you very much. It's been a great 3 hours. We'll see you next week. I'm Fred Penny.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated.